Attend the court. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good afternoon, everyone. Before we start with argument today, I'd like to take a moment to thank a few people who helped pull all of this together for us. First, to everyone who's here today, thank you for assisting the Supreme Court in improving civics education in New Mexico by taking advantage of this opportunity to witness our judicial process in action via live oral argument. On behalf of the court, we'd like to express our gratitude to our host, Northern New Mexico College, President Hector Balderas, and the staff that assisted Amy Pena, Sally Martinez, Sean Madrid, Juan Gallegos, and Joanna Case. We'd also like to welcome the schools attending in person, which totals about 225 students and staff from various schools. I assume you're out there. All we can see is the first two rows. These schools include Pojoaque High School, Mesa Vista High School, Peñasco High School, Taos High School, Santa Fe Indian School, Zebedee Middle School, Espanola High School, Los Alamos High School, and Northern New Mexico College. We also know there's some schools watching online today. These schools include Newcomb High School, Data Charter School, and the Great Academy Charter School. We would like to welcome our family and friends, including Justice Thompson's sister and parents, our Deputy Clerk of Court, Lisette Romero Cordova, her husband, daughter, and mother, as well as our law clerks and staff from the Supreme Court. I would also like to thank our Supreme Court Law Library for preparing a wonderful lesson plan for the teachers around New Mexico regarding today's case. And lastly, I'd like to thank counsel who has agreed to join us in this endeavor of civics education today. Mr. Lammons, thank you for your second round. He has joined us previously. And Mr. Forsberg, thank you for joining us in this as well. We really appreciate it. With that, we are going to get started with the argument. This is case number S-1-SC-39163, State of New Mexico versus King. Can I have entries of appearance, please? And Mr. Forsberg, it looks like you have reserved 20 minutes for your argument in chief and reserved 10 for your rebuttal. Is that correct? Yes. All right. Thank you so much, Mr. Forsberg. You can take the podium.
May it please the court and opposing counsel. A police officer without a search warrant asked Eric King if he could search Eric's truck. When Eric said no, as the federal and New Mexico state constitutions permit, the officer said, "Based on your refusal, I'm going to tow and impound your truck." The officer arrested Eric on an outstanding warrant that he had, and he did indeed seize the truck. He had it towed and impounded at an impound lot in Farmington. Sometime later, the police had a drug-sniffing dog sniff the car at the impound lot, and the dog alerted as though there may be drugs in the vehicle.
What does the record tell us about the regular practice when a vehicle is impounded and the use of drug-sniffing dogs?
In this case, Your Honor, the trial court judge remarked that this kind of seizure and towing a car in order to get it sniffed is what I believe the judge called routine practice in Farmington. And she was surprised that it had not been challenged up to that point. And I share her surprise. It appears although the record does not make this explicit, it appears that the Farmington police, rather than calling a drug-sniffing dog out to a traffic stop, which they are permitted to do, as long as it doesn't take too much long time, that instead they simply seize vehicles and take them to the impound lot, and then presumably once they've got a bunch of vehicles in the impound lot and it's convenient to have a dog go and sniff them, they have a dog go do drug sniffs. That's a very convenient practice for the government and the police, a very inconvenient and I argue unconstitutional one.
Well, those
for
are
the
two
police
different
department.
things, right? One's inconvenient, one's unconstitutional. If they would have simply put cones around the truck and run a dog around it, where would be the constitutional infirmity there?
Yes, Justice Thompson, provided that they did not take too long in order to do it while they had Mr. King detained there would have been no problem. It is well established that the police can use dogs to sniff for drugs at a traffic stop.
But your challenge is to the impoundment primarily, correct?
Yes, our position is that the seizure, not the search, was the problem.
So why under the typical inventory search factors and doctrine would this impoundment be improper? Why? I don't understand why this would be improper. The vehicle was parked in front of the business. The defendant was arrested. It seems to me that they had there was nothing illegal about them impounding the vehicle. So tell me why I'm wrong.
Yes, Justice Zamora. The reason is that a person has an interest in their property as well as their privacy, and that is why the New Mexico Constitution protects both searches and seizures. And this was a seizure. Mr. King did not ask the police to move his vehicle. There's nothing in the record to indicate that it was illegally parked. It was in a parking lot. It wasn't obstructing traffic. He had every right to leave his car there. The question is not whether there is anything.
Forsberg, as I understand it, the truck was parked on the sidewalk and then partially blocking the business that it was parked in front of. That's different than saying it was just parked in a parking lot.
No, Justice Vigil, it was parked right next to a business in a parking spot, is my understanding. And there is an exhibit that shows, I believe, a picture of it next to the business.
Mr. Forsberg, isn't there also an interest in police limiting their liability? Where does liability of the police come in terms of protecting the vehicle?
Yes, Justice Vargas. And I would suggest that the police did not get responsibility for the vehicle or liability for the vehicle until they had seized it. If the police had simply if Mr. King had simply wanted to leave his vehicle there, the police could have simply left it there, and then the police would not be on the hook for any problems that might arise. By seizing the vehicle.
You're assuming that they would be off the hook, but the minute the catalytic converter is stolen from underneath the truck, wouldn't your client be making a claim against the police for lost property?
Well, Justice Bacon, it's always possible. I recall in law school, they said your clients always want to know how to keep from getting sued. There is no way. The only way is to win a lawsuit. And I would suggest that it is exceptionally difficult to prove that the police department is responsible for damages in a situation like that.
So does that lend itself to some infirmity in the Williams case? I mean, that's one of the bases of Williams, is this concern that the police will have liability for property that is damaged, stolen, et cetera, if left behind after an arrest.
Yes, Justice Bacon. I believe the law has gone too far in that direction. First of all, I would point out that there is an absence in the record of any indication that there is an actual problem with law enforcement being sued with regards to damages to vehicles that have been left after they have arrested the driver. I mean, there's simply no evidence that has ever arisen as a problem.
Normally, the standard practice, generally speaking, and it sounds like you're arguing this should change, is that when someone's arrested, Unless the vehicle's at their home or something, it's generally the vehicle's towed. And as a follow-up, I'm wondering, does the business, would you suggest that the police just need to get the consent of the owner of the vehicle or also the business where it's parked?
Yes, Justice Zamora. I would suggest that the permission of the business is not needed. Although it is under the federal test, it is one of the factors that can be considered whether officers tow a car. But I don't believe it's necessary or dispositive in any way. Business owners who have unwanted vehicles on their property have methods at their disposal to get cars towed and tagged and whatever the procedure is. So it's not necessary to have the police tow the car for the benefit of the business. And I would also point out this case is somewhat exceptional in that Mr. King was not arrested for a crime that he committed while driving the vehicle or anything like that. He was arrested on an outstanding warrant. As far as we know, he just forgot to go to court one day. And he got out of his vehicle and the police officer arrested him outside his parked vehicle, and there was no nexus between his arrest and the vehicle.
So what was the nexus in Williams? Tell me what the facts were in Williams, first of all.
I'm drawing a blank now, Justice
Williams
Veal. I
was the
apologize.
guy that went in there and robbed the store, takes off, the police chase him down the street. He's caught, taken to jail, and they find a set of keys in his pocket. They then go back to the scene of the robbery, and they find a car parked in the alley, legally parked in the alley, and they impound the car. The court held in that case that although there was a little bit of attenuation, that there was a reasonable nexus between the crime and the car, and therefore it was properly impounded. How is this case different from that?
Because in your case, Justice Vigil, he was fleeing the commission, the defendant was fleeing the commission of a crime, and the car presumably was part of a getaway plan. I would say that's a nexus. It might be a weak one, but that is a nexus. In Mr. King's case, he was not fleeing anything.
He was fleeing from the cops when they saw him. Speeding, running, and evading, and doing all these furtive movements while the police officers were behind him. He may not have been arrested for that, but an impoundment doesn't require that there would be a whole list of charges related to all of the conduct that occurred before. It need only be reasonable.
Yes, Justice Vigil, and I would suggest that it is not reasonable to presume that there is evidence in the car.
Is it reasonable to presume that the car was related to the fleeing from the officers?
No, Justice Vigil, I don't think the record was sufficient in this case to establish that he was actually fleeing. I believe he drove to a safe spot and parked his car, possibly expressly for the hope and purpose of having the police not tow it. As I point out in our brief, for many people, their vehicle is the most important possession, the most valuable possession they own. And we have gotten into the practice, I believe, in New Mexico, where the police just basically impound a car if they feel like it. If they arrest you for any reason and they just want to look through the car.
But it's that second part of your sentence, I think that is concerning, which is the inventory searches that are following these, because, and I acknowledge we've had a number of cases in this regard, and it's problematic because they're getting around the warrant requirement for search, but that wasn't the case here. I mean, you're arguing for a policy in which in the end of this, there was not that inventory search. They walked a dog around it.
Yes, Justice Thompson.
So,
and
if you can answer that, and then I need to know the exact rule you're announcing here. You're not going to allow an officer, unless the arrest is associated with the crime, to tow that vehicle for any reason?
Yes, Justice Thompson, I would suggest that unless the driver gives permission, unless there is some nexus, some reasonable belief that there is evidence in the car, or that the car itself is evidence or is fruit of a crime, that the officer simply doesn't have authority to seize a car.
But didn't the officer here have suspicion because of the furtive movements that the defendant was making while he was belatedly pulling over once the officer activated his lights and sirens. The record suggests that it took an extraordinary amount of time for the vehicle to pull over. Second, the officer's testimony was there was furtive activity while he was observing the gentleman continuing to drive. And then there was the pipe found in his pocket. And so isn't that enough right then and there for having reasonable suspicion of illegal activity occurring within that vehicle?
I would say not, Justice Bacon. To your first point, the furtive movements, as I believe other jurisdictions have recognized, if police see a movement in a vehicle, they describe it as furtive. All movements are furtive. Secondly, a furtive movement is equally consistent with legal purposes as well as concealing evidence.
Don't we have to look at the totality of the circumstances
Yeah,
here, where we
yes,
have the
Justice
delayed
Bacon.
pulling over, furtive movement as described by the officer, and a pipe in his pocket?
Yes, Justice Bacon. And I would suggest that in totality, they do not amount to enough in this case. As I said, he wasn't fleeing from a crime. He wasn't this wasn't part of a drug investigation. This was just a police officer who saw as an administrative matter that this person had a warrant out for their arrest.
It was an active felony arrest warrant for receiving or transferring a stolen automobile. And the facts continue that he drove behind the defendant, activated his emergency lights to initiate a traffic stop, but defendant continued driving, passing multiple chances to pull over in a safe manner. He noted that during the time defendant was not pulling over, he observed defendant making multiple furtive movements inside of the vehicle. I recognize the movement and the amount of time for the driver to stop consistent with subjects attempting to conceal items inside the vehicle based on my training and experience. So those are the combination of factors. And let me ask you this, isn't there a concern for the officer's safety once the stop is finally made?
Justice Vigil, I would say that there was not a concern for officer safety in order to seize the vehicle. Mr. King was the only occupant of the vehicle, and he got out of the vehicle and was arrested without incident. I don't see why there would be any safety rationale or necessity for the officer to seize the car. Secondly, if the officer's safety was in jeopardy, I would think that he would then search the car immediately because there's something putting him in jeopardy. But in this case, interestingly, the police did not conduct an inventory search.
Immediately after the arrest, he called for a record.
Yes, Justice Vigil.
So he determined at the time of the arrest, I'm going to call a record to tow this car, right?
Yes, Justice Vigil. As the judge in the court below said, this appears to be routine practice for the police there. They just tow everyone's car when they arrest them.
What evidence is there of that routine practice?
Just the judge's acknowledgement of that, Your Honor. That's all there is.
So are you asking us to overrule Williams?
I would ask you to limit it, Justice Bacon. I would ask this court simply to hold that there must be a reasonable basis to believe that there is evidence before the police seize a car in order to apply for a search warrant.
How do we address the potential public safety issues? In the rule that you just stated, how do we address the potential issues where there are public safety issues? In the trial, the suppression hearing, there was testimony that the car's right in front of the door of the business. They needed to get the vehicle out of there, was in the parking lot, was not in a parking spot in front of the business on the side of the road. And it could have been blocking the business because there's a very small area. In the rule that you stated, how do we address that kind of a circumstance where maybe the car is not in a place that it should stay?
Yes, Justice Vargas, I believe if the car is in an unsafe place, that is an exigent circumstance. As I distinguished several cases in my reply brief, that the state had cited, there are cases where, for example, a person is having a medical emergency in the vehicle and the vehicle is in the middle of the road. Obviously, I think the police need to seize it, at least in order to move it to a safe
But
location.
here, why doesn't it fit that definition? I mean, I've reviewed the photo in the record, and the vehicle is not parked in a parking place, and it's almost abutting the front entrance of the business.
Yes, Justice Bacon, I would point out that the photograph doesn't show precisely whether it is or is not in a marked spot or whether it's unmarked, and it is next to the business. I would also point out, Justice Vargas, to your point earlier, that I believe it was the prosecutor who said that it was possibly blocking the business, but there was certainly no testimony or evidence given that that was the
Picture's
case.
evidence. Was the picture admitted, right? Because the picture
Yes.
does show the truck directly in front of a door to the business, the only door. From what, so I would say that, I wouldn't say that there's no evidence. The picture's pretty telling. I have a question. Byram, the 2018 Court of Appeals case talks about, to qualify as a reasonable impoundment, the officer's decision must satisfy one of three purposes. And I feel like maybe you just glanced over this, but one is to protect the arrestee's property while it remains in police custody. And that would be a concern to me if it was left just out in a public parking lot. To protect the police against claims or disputes over lost or stolen property. And you were asked about the third one, to protect the police from potential danger. I want you to talk about the first two, because in my mind, there's the vehicle, is after the arrest, remaining in front of a business. It's out in public. It seems to me it would be exposed to potential theft, which then harms both the liability of the police and also the person, the defendant, whose property was in the vehicle. So how do you get around that? And is the only argument just that in addition to these things, now we must require the defendant to give consent? Is that what you're basically arguing?
Justice Zamora, I would suggest that the police don't have a duty to protect property that they've never seized. If the police had simply left the vehicle there, it would not have been the police's responsibility to take care of it. Now, the arguments sound like the police are very concerned for the safety of his possessions, and the policy is designed to protect the driver. I would suggest that the driver knows his own interests better than anyone, and that if
But
he
at that
doesn't
point, the
want,
driver's not in a position to protect his property. He's been arrested. He's on the back of a police car. He's not in a position to protect it. The officer is.
yes, Justice Vargas, but he's in a position to decide whether he wants to leave it there or he wants it under police protection. I would offer as an analogy, when police arrest a person, that person's house may be unprotected. That doesn't necessarily give the police the ability to seize the house in order to protect it.
Their house isn't in a public parking lot or obstructing a business.
Well, in a public parking lot, Justice Zamora, I would suggest that, well, right now, a lot of us are parked in a public parking lot. We park our cars in public parking lots all the time. There's nothing in the record that suggests that, as I've said, that Farmington is such a lawless town that a car left in public is just bound to be seized or stolen. People are certainly permitted to park their cars in public, and I don't think that a concern for their property, for the safety of their property, automatically gives the government a right to seize that property ostensibly in order to protect it.
So
Although
going
I would
forward-
suggest the real reason, I'm sorry, Justice Zamora, the real reason that police seize cars is they want to search them. That's the ultimate end all the
So
time.
going forward, are you suggesting we hold that the police officer has to ask the defendant, the arrestee, whether they want their car left where it is or towed, assuming it's in a public parking lot, assuming it's not in the middle of the street?
Yes, Justice Zamora, if there is not one of those other reasons, a valid safety reason or something like that, then I suggest that when the arrest in a case such as this, and this case could limit it and just say, when it's an arrest on an outstanding warrant and has nothing to do with driving and nothing to do with a car.
But wait a minute, you keep ignoring the fact that he was evading the police.
Justice Vigil,
The officer's behind him with his lights and sirens, and he's not pulling over. Is that not a crime?
and Justice Vigil, he was not charged with a crime.
Doesn't matter.
And I would suggest that this is a point of contention that is often disputed, and that is when the police turn on their lights, do you have to immediately pull over, or do you have to pull over as soon as it's safe, even though it might be an unlawful parking spot, or should you go to a safe parking spot? There are people who would advise you, if you're stopped at night, you should drive to a well-lighted parking lot before you stop. And I understand the police very fervently believe that the instant their lights come on, your car should be angled directly towards the ditch, and that's that. But I would suggest that a lot of people believe that there should be more flexibility in determining where you stop, because once again, an officer who's intent on searching a car, and this isn't the case in this case, but in some future case, it will happen. The officer will intentionally stop it somewhere unsafe simply in order to gain a reason to seize it and then do the inventory
So,
search.
I'm sorry, go ahead.
You, please feel free to ask your question, but Mr. Forsberg is 3 minutes
of
over time.
So we've not touched on this. You say that the real reason he did this was so he could impound the car and search it. That is that you're arguing, to use my phrase, a pretext seizure.
Yes, Justice.
We have pretext stops that are deemed illegal under New Mexico Constitution, but there's no law saying there's pretext seizures.
Yes, Justice Vigil, and if you'd like, I can address that as soon as I come back up for my rebuttal, because I see I'm already several minutes over.
Yes, thank you.
Okay, thank you, Justice.
Mr. Forsberg. Mr. Lamon.
Thank you, Justice. If I may, I want to just touch briefly on a procedural issue here. As I understand it, on March 25th of last year, this court granted the petition, in quotations, on all questions as presented in the petition. And as I understand it, the petition presents only one question: whether a police officer can automatically seize a legally parked car simply by arresting the driver. And that's on page 1 of the petition. But it would seem that because of New Mexico's strong preference for warrants, the answer to that question would always be no. There's no such thing as just being able to, this blanket automatic, if an arrest is made, we can search. So it gives me pause, because it seems like there should have been a second or third question in the petition for the court to afford any relief if it agreed with Mr. King's arguments. And the reason I say that is, this has come up with other petitions. I had one before this court in State versus Shane Medina recently, and it was a similar argument made there, but it was, if you want the Supreme Court to afford relief, you have to ask them to grant cert on enough questions to do that. So if you only ask the court to review one question, but they need to consider 2 to grant relief, then the petition should be quashed. So that's the procedural argument for the state here, is that question doesn't get us there. It should have been followed by, in essence, what's being argued now, but wasn't something that review is granted on. The reason I say that it's never automatic is because this court said in State versus Letitia T. in 2014 that our courts have historically recognized that it's not always reasonable to require a warrant, and have developed a number of well-established exceptions to the warrant requirement. Among the recognized exceptions to the warrant requirement are exigent circumstances, consent, searches incident to arrest, plain view, inventory searches, open field, and hot pursuit.
And
And
that,
yes, Justice Thompson.
that is a large door that the state has been driving through for quite a while, which is the inventory search.
Yes.
And that is the concern, at least of me, which is we see quite often, as an exception to the warrant requirement, they're finding a reason to tow the vehicle, and then they're doing an inventory search. And sure enough, what do they find? And it's problematic because it's an exception to the warrant requirement. And you know, that is what we have seen continuously used as a means of getting around an officer's obligation to get a warrant.
And I would agree that is a big concern. It's a fair concern. But what I would also say in response to that is that we have the requirements. Those have remained in place. It's not, and so the officer has to be within those three requirements. I would submit to the court that Williams is still good law. And one of the ways we know that is because 5 years ago in State versus Davis, this court reaffirmed those principles. The lawful.
Clemens, for the benefit of, for my benefit and the benefit of the students, what are the three requirements for the impound and inventory doctrine that you referred to?
Yes, Justice Vigil. The first is lawful police custody or control. And when we look at the arguments that Mr. King made in the district court and what the order denying suppression said, that wasn't challenged. That seems like clear law that when you arrest someone in an automobile on an outstanding warrant and there's no passenger or anyone to give the keys to, and I think Justice Nakamura talks about this in that opinion, but it's the act of a lawful arrest that separates them from the vehicle and makes it so that they can no longer protect their own vehicle.
And
so
what is the second requirement?
the second is established police regulations that are actually followed by the officer. And in here, that wasn't challenged in the district court. They assumed that was correct, and we don't have any evidence that it wasn't.
And the third requirement?
The third requirement is that the search be reasonable. And so that's where, to Justice Thompson's question, that's where this court can look closely at the fact pattern and say, you know, on this fact pattern, it was reasonable in this case, but not reasonable in this case. And
Where
so,
in any of those three requirements does it allow the police to get a dog to walk around the car to sniff for drugs?
I didn't see that. That apparently is not a search in New Mexico, although that is a search in other places, a dog sniff. So that's apparently not a requirement.
So it's not an inventory, an impound and inventory search. What the dog did.
It's not a search, and so no warrant is required. And if the police lawfully could impound that vehicle at the time the call to the record was made, and the sniff is not a search, I don't see a Fourth Amendment or an Article 2, Section 10 violation. If anything,
Should we declare that a dog sniff is a search?
I don't think so, because that wasn't the issue below, and usually this court is not it doesn't reach issues that weren't argued below and weren't preserved.
Was it preserved at the trial court level?
I don't believe so. If we can go back, thank you, Justice Zamora, for that question, because I wanted to get to this. If you look at the motion to suppress, the only basis for challenging the impound cited is the automobile exception, which, as we know, is different than the impound and inventory exception. And the fact that an automobile is the object being seized in the impound doesn't mean we apply the automobile exception, because the requirement's there. And I don't know if Justice Hill is going to ask me this, but I'm going to go ahead and answer it anyway. But those two requirements are different. They are probable cause and exigent circumstances. And here the officer, although Justice Vigil is right. When you look at the lapel camera here, it's beyond dispute. Mr. King's not pulling over right away. He's going for a while. And the detective testifies at the suppression hearing, I saw him leaning over and making furtive movements. And he also testified that based on any experience, people often do that to hide weapons or narcotics. He couldn't say he was doing it in this case, but he did find it odd.
On the facts of this case, are there any bumper guards to be put in place? Because Williams, to me, yes, it's the law of New Mexico, but it is such a low. I mean, it's a very, very low bar.
Right.
Because the police are always going to say, we were concerned for the property, we followed our procedure, and I had a good enough reason to
Right.
tow the vehicle. It's
And
really
I-
low. So are there any bumper guards that could be put in place that would be
Right.
consistent with the law in New Mexico already?
Well, I think one of the things about it is it's not really when we're talking about whether a seizure or a search is reasonable or unreasonable. It's never what the officer says. And I did bring a case with me, also titled State versus Williams, but it's out of the Second Circuit. Let me see what I did with that. But what it makes clear is that the court's hook, if you will, for examining this is found here. It says, in general, an action is reasonable under the Fourth Amendment, regardless of the individual officer's state of mind, as long as the circumstances viewed objectively justify the action. And it cites to a U.S. Supreme Court case called Brigham City at 547 U.S. at 404. And then it says that a case called Laley versus City and County of Denver at 477 F Appendix 522, page 524. It's a 2012 10th Circuit case. You know, it cites those cases being for the same general proposition. So that's it seems like where the analysis has to take place. But what is
So if we're objectively looking at the facts here using the Second Circuit Williams case,
yes.
what are the facts that you believe support the reasonableness of the towing and subsequent dog sniff?
Well, as somebody who I want to point out first, I don't want to make too light, but having lived in northern New Mexico and specifically choosing Aztec over Farmington for some reasons that deal with safety, I can say that when you move, if you watch the lapel camera, they start off in a residential neighborhood. I think that's on Bluffview. And as the car approaches the intersection of Murray, you can see the neighborhood change into what I would call something probably zoned business district. And then you see a change. And when the car makes the left, you start seeing businesses. And I can't remember who said it. Maybe it was you, Chief Justice Bacon, or Justice Zamora, but it was absolutely right. When you look in that, he's not pulling over for a while. And again, I agree with Mr. Forsberg that furtive gestures isn't going to be enough under the automobile exception. It's certainly not probable cause, but you don't need it at this point because there's an active warrant for a felony, as Justice Vigil pointed out, and it has to do with vehicles, receiving or transferring stolen vehicles. And Detective Babadi knew that. He recognized the vehicle because it used to have California plates on it. It now had New Mexico plates. I believe it was the Chile plates. But he knew he had a warrant, and he recognized him driving the car, and then the car doesn't stop. And then it doesn't park really in a parking space. When you look at that lapel video, I mean, if you see it differently than me, that's fine, but I didn't see any painted lines. And I think as Justice Zamora said, it's right up against the building. It's like a cinder block squared off building, and it's almost right in front of the door of this auto parts store. And so I can't imagine the owner at 2:20 in the afternoon, the owner would not want that vehicle there, is my guess. I mean, it's not in the record, but it's not exactly parked well. There's a sidewalk here. You see it. The road is right here. There's a pole And then there's very little space to walk. You do see a gentleman walking when you look at the video back this way, and he doesn't have a lot of room. He's trying to walk on the other side of the truck next to the store and kind of get through as the officer is making contact on the driver's side. So it's in a business district, and he's arresting someone on a felony warrant, and they're going to have to be booked. And they may or they may not bond out that night. It may be the next day. It may not be.
So you're hanging your hat on, didn't pull over right away, didn't park particularly well, and an active warrant. You seem to say meh to
No,
the
there's
furtive
more.
movements. So
There's more.
what's the
What's
more?
the more?
Mhm.
It may, to me, in Farmington, New Mexico, at night, in a district that's not residential, where you're going to have people there at night, I wouldn't be parking it there and taking that chance for the owner's car or for my agency's vehicle. Agency, I wouldn't want a suit if that car gets stolen, if the catalytic converter only gets stolen. It's night. That's not going to be attended unless this person bonds instantly, which in my experience, it takes a while to get booked, even if you can get a
About
bondsman.
location and time of day. You've added
Well,
location and time of day to your list.
Character of the neighborhood, because it's a residential district, and leaving that overnight leaves it open to more risk of,
So let me take
theft or
some of those
vandalism.
things away,
yes,
because we write opinions for something that's broader, as you know, than just the case
Yes.
in front of us. So
Right.
what if this was a residential neighborhood, daytime, parked legally, next to the curb, and an active, and pulled over right away, active arrest warrant? Would the officer be within the boundaries to tow the vehicle upon arrest then?
well, and I'm getting back, but I'll come back to it. But under State versus Williams, absolutely, and that was the law at the time of the suppression hearing. But
And remember, I said the hurdle in Williams is,
yeah,
an inch off the table, but
I know. I think there's enough. There are enough factors here. My concern is, whatever the rule is, that's going to have wider application. If the court chooses to do that, you.
would consent cure this?
Well,
So
well,
if
yeah,
if the
right.
suspect says, "I don't care, I want my car to stay here," should the officer then say, "Well, you have consented to me leaving your car parked wherever the heck it is, and now I cannot impound it unless there's that reasonable nexus or exigency and,
Right.
and the like." I mean, those are going to be the exceptions, but the general rule
Right.
being if
Right.
the suspect says, "Please do not tow my car," and it
Right.
satisfies those criteria, why not make that the rule and avoid this, what seems to be routine every single time there's an arrest, impounding the car?
Well, I don't, based on other suppression cases I've had out of Farmington, one which is before the court now, I don't think that happens in every case. The policy gives them some discretion, and you can see in some instances the department going, hey, to a passenger, can you take the keys or not take the keys? Oh, you don't have a driver's license, I guess I'm not going to give the keys to you, that sort of thing. So I think there are other factors, but I would say you're eviscerating some of the rationales for the impound and inventory rule in the first place, because some of them have nothing to do with what the driver wants.
What are those? Because I think I was going to ask you that. It's part of the police officer's community caretaking function, this
Yes.
impoundment and inventory search. What is
Right.
the reason? Why is that an exception? And I know that's a broad question, but I do think it's important to highlight.
Yeah, right. Well, I think that's that's the rub here, right? It's police officers are asked to do a lot, and I mean the best quote on that, and then I'll try to roll into your question here. But when we're looking at Byram, at paragraph 10, it just says the community caretaker exception to the Fourth Amendment developed from the understanding that police officers frequently interact with citizens without an investigative purpose. Police have dual roles, acting as criminal investigators and as community caretakers. The caretaking function is totally divorced from the detection, investigation, or acquisition of evidence relating to the violation of a criminal statute. And so they're as part of their job, they're forced to wear both of these hats, and sometimes both at the same time.
But-
And so, go ahead,
I'm
Justice.
sorry, you can finish your
Oh,
question.
If I can just finish the sentence on that. So what the officer did here is, what did he do first? He asked for consent to search. Why would you do that? Because it's the easiest way to comply with the Fourth Amendment and Article 2, Section 10. There's not some big test. We don't have to worry. It's the person consented. And so that's where you would expect an officer to go first, because it's the easiest. Why, if a suppression motion is filed later, well, why did you search it? You didn't have a warrant. Yeah, but I asked the person and they consented. Then you may shift to other roles. You may shift to your community caretaker role. The officer may go, okay, I'm arresting someone on a felony receiving charge. They're not going to be out here.
That's not consistent with what this officer said in this case. And I point to the police report and then the search warrant. In the police report, he writes, Officer Babadi writes, due to the drug paraphernalia and furtive movements I observed before the stop, I requested a tow truck to my location. I advised defendant that the vehicle will be towed and I will apply for a search warrant. The search warrant has the stop concerns, probably the furtive movement, the presence of the drug paraphernalia, and then the canine.
Right.
And I think it's an interesting question about, at this point, when it's in the yard, he's trying to build probable cause for a warrant. He's not bringing the dog to the car. He's bringing the car to the dog.
Right.
Because the one thing, the difference between the police report and the warrant is this canine, which to a trial court judge, and you have a few of them, would be convincing for a search warrant. But
Right.
it seems to me what is in this officer's mind from the beginning is not a caretaker. I'm not there to make sure they can get in and out of the business or someone doesn't run into the car. I'm towing that truck so I can get probable cause and run a dog through 15 trucks that are in my lot down. Should that not be a concern? The one thing that they built, one of them, significant one that they built that search warrant on, was a sniff.
That's right. And that is,
It took 90 minutes. He didn't bring the dog to the car. He took the car to the dog.
he couldn't. And it's also in the record when he testifies, they ask him, why didn't you bring the canine to the location, to the auto parts store? He said, I don't believe there was one. And then at one point he qualified it a little bit. He said, I'm not 100% sure. But then he said, there wasn't a canine available.
They found one 90 minutes later, and it's,
Was it 90 minutes? I was looking at the affidavit and I wasn't clear. I thought it was the next day, but I trust the court to look at the record on that and see. I thought it took him, well, hold on. I don't know. I would just ask the court to rely on the record. What I wanted, I may be getting mixed up all the time it took between the sniff, the submitting the affidavit for the search warrant, having that granted, and then having that executed. So I'd ask the court to rely on their own memory on that if I'm getting a little confused up here. Here's the exact wording that I have on this, and it's, hey, sir, just so you're aware, this is Detective Babadi. Based on your denying his consent to search your vehicle, okay, I'm going to tow it. I'm going to apply for a search warrant. That's pretty much it. The judge might say yes. He might say no. I'm going to apply for a warrant. I'm not going to keep your vehicle forever. Okay, there's a process that we have to go through. I'm going to apply for a search warrant. I'll put into the affidavit what I saw and what you told me about the meth pipe. That's it. If the
plus a
judge
canine
says,
search.
yes, search it. So he didn't search at that point because he's telling the important context here is he's telling King this at the scene before he's ever called out a canine to the impound lot. And this is at on Exhibit 1, 231:47 in the afternoon to 232:16 if the court needs that record. But I know sometimes up here we're supposed to cite to the record. So I'm doing it on that one because that's the exact language. As far as I was able to hear it now, there were things that were unintelligible on
Mr.
this.
Lamons, getting back to the Chief Justice's
Yeah.
question.
Yeah.
What kind of bumper guards can we put up or exist to make sure that officers aren't pretextually just saying, I gotta impound this now that I've got you
Right.
under arrest?
It has to be objectively reasonable. And that's that Williams case out of the second I was quoting.
Don't they just have to say at that point, I'm worried about your vehicle being stolen, so I'm going to impound it?
I don't think that's enough. I think you have to look at the neighborhood and I think you have to look at the type of arrest warrant. There's a case decided in 2022 by the Court of Appeals, State versus Jim. I think I mentioned it at some point, but that's an interesting case. Also out of Farmington, the Dunkin' Donuts over there at San Juan Plaza. And in that one, you don't have a felony warrant. It's a criminal trespass. You have someone parked outside Dunkin' Donuts. They're not sure why. The person won't leave. They leave for a little or move to the other area of the shopping center, then come back. And so the security guard finally calls and says, hey, can we get some help, police and all? And they go out and eventually they impound. And the interesting part of that opinion is that the Court of Appeals finds the impound lawful, that the impound is reasonable. What the court finds, and this is the only change since State versus Williams, other than the clarification that Nexus in Davis, that Nexus is not a fourth requirement. There are only 3 requirements for the impound and inventory, but this is the change. In that case, there's a double locked, I believe, gun safe in the back seat. And they say in that scenario, the person has a heightened expectation. So what the Jim court did is said, no, the impound's fine. But at that point, you needed to go get a warrant. And the interesting thing, the reason I talk about that is because the very first case out of this court that that came after, I'm blanking, South Dakota versus Opperman, Ruffino in 1980, that's the one that laid down these requirements that I was reciting to Justice Vigil, trying to get 100% on that particular answer. But what they said is, if you do this impound, the preference is to, then get a warrant. And so ultimately that's what the officer did here, even though he used a dog
Just to go
sniff.
back to the impoundment, because
Yes.
that's really what's at issue here.
Yes.
Because I think part of it's sort of how Williams lays it out. And I think Byram does a better job of really saying what is at the heart of this is the reasonableness. And that's really true of any Fourth Amendment analysis or any Article 2, Section 10. So if I'm hearing you right, is what you're telling this court is it's the parameters of reasonableness and maybe the factors that we should be considering in determining reasonableness that doesn't give police officers the freedom to just tow any vehicle every single time someone's arrested.
That's right, Justice Zamora. What you and Justice Vargas have asked me about, where are the bumpers? Where are the safeguards? One of them is you've got to have established police regulations, right? But now pretty much everybody does. And so that's not a problem. But it used to be, I think,
Hey, you can tow the vehicle. We've seen a
Well,
lot of them.
this one has, I think, 14 enumerated situations where you can do it. The driver's revoked, the driver's arrested, there's no one to give the keys. There's a whole bunch, so it fits within. So that's not one of the big bumpers or guardrails. It really is this reasonableness. But my concern is, it seemed to me like the argument was that an exigent circumstances requirement should be grafted on to the 3 impound and inventory requirements we have. So it's not just lawful custody and control, plus following established regulations, plus it being reasonable. We now have to have an exigency to impound the vehicle. And the state's position is that, I'm not going to say this artfully, the state's position is the court shouldn't go there. It should stick with
And isn't
these
that because
requirements.
exigency could be one of the things that demonstrates reasonableness? It's subsumed in the reasonableness
Right.
context because that could be one of the things, depending on the fact pattern, that tends to suggest that.
Right. That could be one of many factors, but just in that reasonable inquiry. But to say no, if you don't have exigent circumstances, then we suppress. The problem with that is then it narrows the community caretaking function too much. I mean, we have a lot of police officers that want to do a good job and want to be liked in the community, but they're not always liked in the community because of the calls they make, some right, some wrong. But if you take away the community care, I know people talk about community policing and stuff, but if you take away the caretaker function, I'm not sure that's helpful. I mean, you could get the opposite. You could have people just saying, well, fine, we're going to leave your car unless it's dab in the middle of the road. We're just not going to do that function anymore. And we're just going to leave cars.
Well, I would guess that if that were the decision that it was announced by the court, they would be bringing a sniffer dog to every single traffic stop.
Yeah, and the record doesn't show that here. The record, I can't tell you what the thought process was on doing that. Was he, you're trying to build probable cause after you already have authority to seize the vehicle for other reasons? I'm not sure what he thought, but again, when we go back to Williams, it's not the subjective intent of the officer, and where the court can really watch over this and be the gatekeeper on this stuff is in that reasonableness prong and see whether this was objectively reasonable. But look at Davis.
Questions?
Can
The chief's
can
going
I-
to get on me because you only have 32 seconds.
I have 32 seconds.
So, I better
Okay.
ask him right away. Mr. Lamans, you cited a case which makes, on the one hand, it's got to be a proper impoundment. And then it's got to be, on the second part, it's got to be an inventory. And so you said in that case, the inventory that was done was not reasonable. Can you give me the name of that case, please?
Are you talking about the Court of Appeals from
Yes,
22?
that one
Jim?
you were talking about.
Jim, yeah, the Dunkin' Donuts case.
Dunkin'
I'll refer
Donuts,
to it as-
okay.
That's how I remember it. But
And,
do you want the site?
oh,
I know I have it. Just, it was decided January 31st of last year, so it's 2022 NMCA -020. Oh, I'm sorry. It's 2022 NMCA 22. And unfortunately, my time's out, and so I can't talk about Davis, but all right.
Thank you, Mr. Lamans.
Thank you.
and in my defense, I'm a little colorblind between red and green and orange and all that, so sometimes I can see the numbers.
Okay.
Thank you, sir.
Mr. Forsberg.
Before I give Justice Vigil an opportunity to re-ask his question, I'd just like to point out some of the context of this case. This court often gets cases where drivers give consent for the police to search their vehicles. And quite honestly, as attorneys, we wonder, why in the heck did you do that? Why did you give them permission to search your vehicle? And I believe this case is a perfect example of why. The officer told Mr. King, and I believe this is a direct quote, based on your refusal to consent to a search, you don't want me to search your car? I'm going to seize it. And it's going to cost you hundreds of dollars and hassle to get it out of the impound lot. And I may search it anyway, because now that I've seized it, I can do an inventory search, or at my convenience, I can have a drug dog sniff it. And so I believe in large portions of our community, people have just become resigned to the fact that the police are going to do what the police are going to do.
But Mr. Forsberg, I think you said in your opening argument that the police could have put cones around the car or whatever and called a dog to the scene and done a sniff, no problem.
Yes, Justice Vehil.
But your problem is they took the car to the impound yard and did the dog search there.
Yes, Justice Vehil.
So what's the difference?
The difference is by towing it and taking it to the impound lot, they moved it somewhere that might be inconvenient. They incurred expenses that my client would have to pay, hundreds of dollars, maybe thousands of dollars. I fortunately don't have much personal experience with tow yards, but I've heard from plenty of people who do. It's quite expensive and quite inconvenient.
But isn't
And
it inconvenient for the business owner? There's a big truck blocking the entrance to their business.
and as I said,
So it
Justice
could have been
Zamora,
towed anyways by the business owner, I mean, I'm not, maybe not, but I would think if you're obstructing a business, and I would think maybe the business owner could tow it.
and Justice Zamora, that would depend on the local regulations. There are usually procedures for when a business wants a vehicle towed. A lot of times they put a sticker on the window and you've got 24 hours or something like that. You see those vehicles by the side of the interstate all the time. They've got a sticker on them that says they've got notice that it's going to be towed if they don't move it. And those procedures are in place precisely to make sure that people's cars don't get towed willy-nilly. And in this case, that's basically what happened.
So,
But
but,
there-
oh, I'm sorry.
No, go ahead.
So getting back to my question, it may cost money, it may be inconvenient and so forth, but does that make it unconstitutional?
Yes,
That's the reason for my question.
and I would suggest, Justice Vigil, that the problem here is that practically, in this case, the police violated what's called the constitutional conditions doctrine, in that they played one constitutional right off against another. Mr. King had a privacy interest in his vehicle, and he was allowed to refuse a warrantless search. But the police then turned around and punished him for doing that by seizing his car and taking it, and then
You got a refusal, and they could still bring a dog out there. And by your rationale, that would be constitutional.
yes, Justice Vigil, and it wouldn't have cost my client a thing.
I don't think the cost is, you seem to be differentiating Justice Vigil's scenarios by saying it's the cost. Well, the cost isn't what makes things unconstitutional. So either the dog sniff is a problem or it's not. And so I'm not sure I understand the line that you're trying to draw. So that's one piece. Second is, you said they willy-nilly towed the vehicle. Well, Williams suggests it can be willy-nilly because Williams says no compelling need must be present to justify impoundment of a vehicle incident to arrest.
Yes, first, Justice Bacon, in regard to cost, I would say cost does sometimes make things unconstitutional when the government is imposing a cost for a person exercising a right they have been given.
It's not the issue in front of the court. It's not part of the briefing. It's not part of the
Pre-
cert question.
precisely.
I mean, we've gone far afield with this idea that the cost is what's the difference between taking the dog to the car or taking the car to the dog.
Yes, Justice Bacon. And I would suggest that when drug sniffs are done pursuant to a traffic stop, it must be done within a reasonable amount of time. By seizing the car, as I said, very convenient for the police, just line up the cars, and whenever you happen to have your drug dog on duty, just go ahead and sniff them all at once. And very convenient for the police, very inconvenient for the drivers whose cars are towed, and I would suggest it infringes on their right to their personal property. And that therefore this court should view with a very jaundiced eye the kind of practices that unfortunately have become all too common
It cut
across the
both
state.
ways. I mean, it could be more costly if someone broke into the vehicle or damaged the vehicle, took valuables from the vehicle. That could be more costly, presumably, for the defendant than the cost of towing. I mean,
Yes.
part of it is safeguarding their property, and
Well, yes, Justice
property
Zamora.
left out vacant. People put expensive things in their cars, or the
That-
car itself could be damaged. I guess I can see it cutting both ways. I do see your point. I'm just thinking that economic infringement you're talking about really could be argued both ways.
And Justice Zamora, I would suggest that the government's position expresses a lot of concern for community caretaking and protecting the property. And I may be dating myself, but I would quote President Ronald Reagan, who said that the scariest words you'll ever hear are, "I'm from the government, I'm here to help you." And this is a similar case. The police and the state on appeal are naturally so concerned with protecting the property of the person who's been arrested. But I think, as this court has already expressed, there are concerns. That's just a rationale that the police use. We just heard that community caretaking is divorced from investigation. In this case, the officer never expressed any community caretaking interest. His investigation was the reason for the seizure.
Can you have a dual role, community caretaking and investigation? That's consistent with the Constitution?
I believe in some circumstances it might be possible, but in a case like this, I think that because community caretaking is an exception itself to the warrant requirement. And if you call everything community caretaking, then there's an exception
That's true.
for everything.
But the community care, often in the inventory impoundments case law, they kind of say it's rooted in that community caretaking function. I agree it's separate, but the rationale is the protection from liability, potentially the protection of the police and the property of the defendant. I mean, that's kind of been those three big principles have kind of been the so-called community caretaking, for lack of a better word. It's just all over the case law. They say it's kind of drawn from that community caretaking.
Yes, Justice Zamora, and I would suggest that the state and the law has gone too far in that direction and making the exception almost the rule.
So let me ask you this, because I think Byram did a better job of, well, not better. I don't want to say better. Williams may not have been as clear as perhaps looking back, Byram's really focuses on the reasonableness umbrella that all Fourth Amendment law. Do you think that kind of clarification of this area of law, somewhat how Byram did it, would be better, or Jim?
I think it would be helpful, Justice Zamora, and I would point out, as I've been trying to emphasize, that the New Mexico Constitution in particular, and I cited a Supreme Court justice in my brief in chief pointing out that the Constitution protects against unreasonable searches and seizures. And our state constitution makes no distinction between searches and seizures. And I think sometimes there's a tendency to follow the federal line, which is kind of to downplay the importance of seizures and emphasize privacy. But yes, Justice Thompson.
So in your 30 seconds, I'll let you answer Justice Vihill's original question. Do you agree we have not accepted in this state the concept of a pretextual seizure?
I agree this court has not explicitly adopted that, and I believe it may be time for this court to do so. If there are no further questions from the court, thank you.
You gave us 6 seconds back, Mr. Forsberg. Thank you, counsel, for your presentations today. They were quite helpful. The court is going to go into recess now to see if we can come to a conclusion in this case. In the meantime, I believe counsel are going to answer questions from the audience, and then we will come back out and either announce a decision or tell you that we've not made up our mind, but then answer questions as well. Thank you so much.
Court.
Hey. Thank you all so much for your patience and it was thank you all for being very quiet. I know it's really long. Each side gets half an hour and it can seem to take, quite some time. So thank you all for your cooperation. I'm just going to start with introductions. My name is Lisette Romero Cordova. I'm the Chief Deputy Clerk of Court for the New Mexico Supreme Court. All that really means is I'm an attorney for them. I help them do their job. And I'm also a very proud graduate of Mesa Vista High School. So thank you, Trojans, for being here. And then we also have our two attorneys here who argued the case. We have Mr. Ben Lamons from the state, represents the state. And then we have Mr. Stephen Forsberg, who represents defendant in this case. So at this time, I'll take any questions that you all might have about the case, about the court, anything like that. Anyone? Yes. We have mics back there, so if you raise your hand, you'll get a mic.
I have a question about the impound and inventory doctrine. When they impound the vehicle, do they have to perform an inventory? Do they always have to do that?
According to State versus Rufino, the 1980 case, an inventory is supposed to be done. So I think once it's impounded, you can't go back for a couple of reasons. One is that it won't be constitutional, but two is it's not going to comply with the police agency's guidelines. Because if you'll remember, the second requirement is that the police department have rules about when the officer can impound and tow and when the officer can't do it. So with Farmington, what I know, just handling a few of the cases, you do have to, it is automatic. Once the decision to impound is made, you must inventory it. And that's, again, for the protection of the person. So they know what was in the car when they took it, and for the department. So if there's a claim that comes back later than saying, hey, I had $1,000 in the console, it's designed to protect against that. And I know Mr. Forsberg might want to answer this too.
I would just point out, I'm not aware that there's any explicit legal requirement that they do. Their policies may call for it. However, I would point out that in practice, a lot of times what the police officers will do in an inventory search is they'll search your car looking for drugs or guns or whatever. And then for the inventory, they'll just write down personal effects. And that's it. So a lot of times the inventory, even when it's done, is very cursory. And as we saw in this case, they didn't do an inventory. And that's not dispositive. The police aren't required to do one.
When they do the inventory, is that a legal search then without a warrant?
It is a warrantless search if the impound was without a warrant. Because, I'll just say that. And one more point, just lots of times the smaller personal effects will not be listed out. They won't be itemized. But what I see a lot is if they do find drugs, whether it's prescription, legal drugs or illegal drugs, they find currency or any items that are of considerable value. My experience has been those are the ones they list out, and then it'll say something like other personal effects. So it kind of depends. But if it's somebody's lighter or something like that, it's probably not going to be listed on the inventory.
Yeah, and I would just point out that the inventory search is an exception to the warrant requirement. Normally, a police officer who wants to search your personal property, if you won't give him permission, and you don't have to, in New Mexico, you never have to give permission for a warrantless search. But if an officer lawfully seizes your car, then he's permitted to do a warrantless inventory as an exception to the normal requirement that you get a warrant.
Thank you.
The other thing I'd point out with consent is if you don't give consent, I mean, obviously there are reasons that have nothing to do with illegality for just not consenting. That's fine. So unless there is another of these exceptions to the warrant requirement that fits, then, that's it at that point.
Oh, I see a hand here. Do you have a question? Can we get the mic down here? Thank you.
Hello. Pardon my ignorance, but I'm struggling to understand the connection between state versus William and this case. Because in my very basic understanding, I would think that if someone was caught, there's a crime scene, and then you find a set of keys in his pocket that belong to the car that's parked at the crime scene, then the car becomes part of the evidence in this case. But how is it connected to the way impoundment happened in the case we are discussing today?
Thank you for the question. It's connected because in 1980 in Rufino, that was when the New Mexico Supreme Court laid out the requirements for an impounded inventory here. And so Williams is decided 2 years later, and it's a different fact pattern than was in Rufino. And it's a little bit different in that than what happened in Rufino, because the court had to decide whether officers could impound under this doctrine, even if the car was legally parked properly in a designated space. And so it was just a different fact pattern, and they had to determine whether there was enough of a nexus between the impound and the arrest, and then whether it was reasonable, whether they thought the impound was reasonable in that case. So as a new fact pattern comes up, you always have to analyze it through the lens of, did the police have lawful custody or control of the vehicle? Because if the stop was no good, it wasn't supported by reasonable suspicion, they just stopped someone randomly, then the inventory, the impounded inventory will not be constitutional. If they stopped someone legally, but then they didn't follow their own rules and regulations about when they can and can't impound, then it's not going to be constitutional. And then that third category is the catch-all. It's like, okay, they've satisfied the first two, but was it reasonable to do this? So that's really where the court can come in and say, and look at all the competing arguments for why it was and why it wasn't. So as every fact pattern comes in, you're viewing it through the lens of existing precedent.
Thank you.
And one thing I would point out that's important to keep in mind in law, and I believe one of the justices even asked, do we have to overrule Williams, is that these cases that we're talking about are approximately 40 years old, which is older than a lot of you are, I'm sure. And the court has had 40 years of experience seeing how those cases have played out. And that's always a question, and the different parties argue it variously, but there are always arguments that after a certain period of time has gone on and the court has seen how something has worked, it might be time to change. And maybe this is one of those situations. But as I said, the cases we're citing are 40 years old. Last week, both me and Mr. Lamon cited cases from the territorial days, right? So a lot of the cases and principles are very old, but the court is constantly reevaluating and seeing, and something that was reasonable in 1980 may not be reasonable today. So we'll have to see what they do with it.
I second all of that. That was just well said. And it is, they have to evaluate. And the last, I mentioned two cases, I think Davis and Jim, one from 2018 and one from 2022. But the significant thing about these cases is their lens has been, these three requirements. And so they view it through that lens. But the reasonableness, what looks reasonable in 2023 may have not looked reasonable in 1990. So you just have to keep abreast of all the changes and to kind of get the direction the court's going in. But it's by no means easy to distinguish all these fact patterns. So there's a lot the Supreme Court has to look at.
I'm recalling in the report that the officer wrote that he did not need a usual reason to pull the vehicle over because he recognized the vehicle and that there was an outstanding warrant. I also recall that he said that he observed drug paraphernalia. So would that fall under the plain sight rule? And how in the world did he see the drug paraphernalia if he was driving? And did he see inside the car when he was driving? That makes no sense.
Yeah, good question. So yeah, if there was an outstanding arrest warrant and at the suppression hearing, the detective said, I'm familiar with him. I've met him before. I've seen him driving that truck, but with California, not New Mexico plates. And so he established some familiarity with the person. And so there was less of a concern because of that testimony. And then you will hear, last he knew there was a warrant, but what the officer did is he talked to dispatch and he wanted to confirm that the warrant that he knew about was still active. And when you look at the lapel camera recording, Mr. King is saying, I talked to my attorney yesterday, or words to that effect. He took care of it. He said he squashed the warrant, but I'll just give you a thing. For courts, the word is quash. So if you're in a law class, you want to say quash. Do not say squash, although it sounds right. But I'm just saying he confirmed it. So once the arrest warrant was confirmed, there was really no issue because police officers do have the right to what do they call it? To execute the warrant. They have the right to serve that warrant on the person. So that wasn't an issue. And I don't know if the police regulations had changed in this case. Periodically, they revise and update, but that wasn't challenged in the district court. So that's why it's not an issue for this court. There was no contesting that the defendant didn't contest that the regulations that were in effect at the time were followed on that. So,
thank you.
Yeah.
I would just point out that like Mr. Lemon said, if the police recognize you and know that you have an arrest warrant out, they can arrest you. And the plain view exception would fall into place, and it is another exception to the warrant requirement. In the law, there are always a lot of exceptions to almost everything. And the plain view exception would be if the officer had walked up to the car and seen obviously illegal drugs just sitting out where he could see them, then the officer could seize them without a warrant. But in this case, there were no drugs in the car in plain view. Hence, they eventually did the dog search and got the warrant.
And then, so that's a little different exception because the rationale for that exception is if you're exposing this to plain view where everybody can see it, why should the state have to get a warrant? You have a legitimate expectation of privacy in those things you protect. Your home, some of your belongings. I think I mentioned a case where it was a car, but the gun safe in the back was double locked. And then what the Court of Appeals said was, no, you've got a heightened interest over what the government has when you take those steps to secure it.
I think we have a question right over here.
Test. Okay. So during some of the questioning by the justices, they brought up the fact that sniffing isn't technically considered search. Am I correct in how I heard that? Why hasn't this been accepted by the courts? I would assume that sniffing has been used for quite some time by now, and so it would seem that it should be considered search because in reality, that's what it is.
Well, that's a good question. And my short answer is courts are split on that. So you have to look at different jurisdictions about what is and what is not, because the baseline is the federal Constitution, the United States Constitution, but states can enact greater protections. And states can say, well, under our Constitution, it affords greater protection to citizens. So even though the Supreme Court doesn't call it a search, we're going to say that it is a search in New Mexico. And so that's one of those things. But the line, a lot of the searches are more intrusive than that. In other words, when you open somebody's car door and you start going through the glove box and the console, and you go under the floor mats and you go into the trunk and you look at the spare tire, that's a pretty intrusive and damaging search. Some courts have held, I believe there might be one court that's held, like if the dog's nose, I'm not sure, I have to look at this, like if it touches the car, then that's too much, so it depends, but it's less intrusive from the sense that the dog is not opening the door and handling things and going through your stuff. It's just alerting to a smell that it's been trained to alert to by, barking or assuming a position.
Yes, I would agree with that. One of the big distinctions about dog sniffing is that a smell is something that you presumably expose to the public. The air that it's smelling has traveled out into the public area. And therefore, it's not an invasion of your privacy to actually have a drug dog sniff something out in the air in public. Some courts have said that the police cannot bring a dog up to your front door in order to sniff, because that involves something in law we call the curtilage, which is the area right around your private residence. And I just recall, just this past week or two, I think in Ohio, a court ruled that a drug dog that put its paws on the car while it was sniffing was a search because it physically contacted the car. And as in so many cases in law, there are 100 different places you could draw a distinct line, and the courts vary in where they draw the line. But yeah, that's the big thing. In New Mexico, it's generally all right to allow a dog to smell what's public property, the air.
I just want to sort of talk about that just a little bit. I think one of the things that they're saying is that your rights can be different, right? Depending on sort of where you are, right? So when you're online looking and they say, well, can you do that? And the lawyer says, well, it depends. It's because that's the truth, right? It depends. In New Mexico, under our Constitution, you might have greater protection than you would have under the United States Constitution, right? But that greater protection that you have in New Mexico under certain circumstances wouldn't necessarily extend to other states, right? If you were in a different state.
I just want to expound on that for a minute. So 2 areas where the protection afforded New Mexico citizens is greater is roadblocks, Alvarez Cardenas or Cardenas Alvarez, I can't remember, but it's a hyphenated, I'm not sure which name is first in the opinion, but that's one area. Searches incident to arrest is another area where New Mexicans have greater protection. So there's lots of areas like that in the law.
And I was just going to emphasize one point that's been made, is that a lot of people speak about the Constitution as though there is only one. In reality, in the United States, there are 51 constitutions. There's the federal Constitution, which overarches the entire country and controls federal authorities, but each state also has its own state constitution. And as Mr. Lammons has mentioned, our state constitution provides some extra protections that the federal constitution does not. And it's very easy to get confused when you read in the newspaper about court cases, whether they're talking about a state constitutional decision or a federal constitutional decision. And that's just something to keep in mind.
The other part of that, if I can add to it, is remember the United States Constitution provides the minimum protections. So each state can go over that and provide greater, but that's the baseline. No state can go under.
Okay, I think we have time for just about one more question.
Hello. So I had a question about the towing part of the car in front of the store. What does the store owner have a right to tow the car? Because from what I heard from context, the car was sitting in front of the door of the store. And I know multiple places that had signs up that you are not allowed to park in the parking lot overnight or even to a certain point of how many days.
Well, I don't think, so one of the things the court is limited to is the record, and that's, in this case, the pleadings and documents that have been filed, but they're also limited to the testimony at the hearing. And my memory is that we didn't have anything. There was, that's something the prosecutor could have done. He could have spoken to the store owner. I think it was 2:20, 2:30 in the afternoon. Business, I believe was open, and it's something that could have been done, but that's just not in the record. There was no testimony about what the owner wanted. But what I would be doing, if I were the person advising an agency and it didn't put the officer at risk, I would be advising him, stick your head in the door and see what they want done with this car, because that might be something that, it's important that the public feel that the police are acting reasonably. And so, to me, I don't know. There might be situations where you can't leave someone who's been arrested that way. But if you have a second officer there, hey, what do you want us to do with this car? It's sort of blocking your door.
Yes, as Mr. Lammons pointed out, on appeal, which is what we're doing right now, we're practicing what's called appellate law. We are limited only to the information that was brought out in the trial court, and it is part of the record. And one of the things that we do as appellate attorneys, I'm sure Mr. Lammons does it as well as me, is wish that everyone had done everything completely differently when they did it the first time. Appellate attorneys are very good at that. In law, it's a lot more difficult than people realize often to introduce evidence at the trial level. It takes a lot of time and effort, and therefore both defense attorneys and prosecutors are really trying to only introduce the evidence that they think is absolutely necessary and that will get them what they want at the trial level. They usually aren't thinking of appellate law down the road. So a lot of times we look back and wonder and think, wouldn't it have been great if this would have happened or that would have happened? But it didn't. And so we just basically, like the justices, have to go off what's in the record or what was done in the trial court.
Yeah, we're Monday morning quarterbacks to some degree. I was in litigation earlier stages in my career, so I've seen, but it's a different mindset. And I don't know what to compare it to, but we have more time to think about these things after they're done than the lawyers in the courtroom that are presenting the evidence and wrangling witnesses in and trying to get people there and trying to ask all the right questions. And it's much more free flowing there. So I would say that, what they do is improvisational. It's more like jazz. What we do is a little more like classical music, and we've got a lot more time to do it.
I see a fellow right in back. Yeah.
You hear me?
Yeah. Yeah.
So the question I have is that drug sniffing dogs cue also on marijuana, but now the recreational marijuana is legal. What are they going to do with those dogs?
Well, okay. I don't know what they'll do with those dogs. They may train them not to react to marijuana and only to cocaine and methamphetamine. I have no idea. You'd have to ask the police canine unit.
Thank you. I think I'm going to turn it back over.
Please be seated. First, I want to say thank you again to the lawyers that were here today. They did a fine job with their arguments before the court. And the court also took particular note of the fact that we felt like you both were very cognizant of the larger audience today. It wasn't just the court, it's all the students that are here. And we really appreciate the efforts you took in your presentations to make things a little more understandable, so to speak. So thank you for that. So after deliberation of the briefs and the argument here today, it is the court's conclusion that the trial court's order denying the motion to suppress was correct. Therefore, we agree with the Court of Appeals decision and will affirm its opinion. Something in writing will follow later, but we wanted to give both counsel and the students that are here today the benefit of the answer to the test question, so to speak. But again, counsel, thank you both very much for everything you did to fine tune your arguments for us and for our audience today. I really appreciate it. So I think with that, our intention was to see if the students had any questions for the court about what we do, how we make decisions, etc. Just silence.
Oh, there's a hand up back there.
Stand up, have them stand up.
If you have a question, why don't you stand up, because I'm having a hard time seeing you in the dim light. Nobody.
Come on, guys. The back.
Way in the back. All right. Because otherwise I was going to call on Lionel. Who's my lawyer.